Private sector employee records aren't covered by the Privacy Act. An employer doesn't have to grant an employee access to their employment records. If an employer handles information as part of an employee record and is directly related to a person's current or former employment relationship, then the employer's conduct is exempt from the APPs. However, this exemption doesn't apply, and therefore the APPs may still apply, if the information is about former job applicants, i.e. those who weren't employed, or contractors or employees of related entities like subsidiaries. Crucially, this exemption doesn't extend to records of an employee's after-hours behaviour, say on social media. Employee records exempted from the APPs may be subject to special requirements under the Fair Work Act 2009. If you're uncertain about handling employee records, seek specialist legal advice. Consider the Employee Records Exemption. It exempts private sector employers from Privacy Act compliance, but only where personal information is handled for an employment-related purpose. If a private sector employer handles personal information for an indirect purpose, then this exemption doesn't apply, but the Privacy Act does. Employers can attract Privacy Act obligations in various ways. For example, by providing employees with extra perks or benefits, such as gym memberships, health services, or insurances, etc. This is because providing these benefits means handling personal information not related to work. Also, employers may track employees beyond the workplace, say through GPS tracking, computer monitoring, video surveillance, or call recording, or via health checks or drug and alcohol tests. Most employee monitoring has scope to capture employees' personal activities. For example, tracking an employee in an employer-provided vehicle during working hours. This relates directly to the employment relationship, so it's exempted from the Privacy Act. Yet tracking the vehicle and the employee in the employee's personal time is likely to result in the collection of personal information. Such information isn't related to the employee's employment. So, in this scenario, the Privacy Act and its compliance obligations apply. But it's not only the privacy laws employers need to consider. There's no general right to privacy in Australia. So, most states and territories have implemented device-specific legislation regulating how and the extent to which employers can monitor their employees. For example, New South Wales has the Workplace Surveillance Act. It regulates the legal use of camera, audio, computer surveillance, and geographical tracking. The ACT has the Workplace Privacy Act. It regulates prohibited, notified, and covert surveillance. Workplace legislation is complex and frequently revised to keep up with technology. Depending on the type of monitoring and the personal information collected as a result, employers must also follow applicable workplace surveillance legislation, plus general surveillance legislation. For example, the Telecommunications Interception and Access Act 1979 makes it an offence for a person to intercept or access private telecommunications without the knowledge of those involved. Or the Surveillance Devices Act 2004, governing surveillance device use by Australian government agencies. The Act also applies to Australian state and territory police when they're using surveillance devices under Commonwealth laws. And of course, health records legislation. Each type of legislation imposes specific employer compliance obligations. You'll likely need specialist legal advice to determine and remain up to date with your obligations. The OAIC commented on the improper collection of credit information by a former employer. The complainant discovered his former employer had accessed his credit file. The former employer had no credit relationship with the complainant. The complainant had a separate legal dispute with his former employer. He worried information obtained from his credit file might impact the dispute. The former employer acknowledged it had obtained the information from the credit file to deal with the dispute. It accepted information should have come through other channels. The former employer offered to apologise and to change its procedures. But this wasn't enough for the complainant. So the OAIC resolved the complaint through conciliation. The former employer paid $1,000 in compensation and provided a written explanation of events. What should employers do? Employers are well placed to demonstrate legal compliance if they put in place and communicate to employees their policies on, the reasons for, and methods of collection of employee information, and explain processes adopted to manage, control, and protect the information collected. The Fair Work Ombudsman provides a guide to workplace best privacy practice. It addresses what information may be collected and retained by employers and whether it can be passed on to others. The guide lists state bodies where you can obtain specific information about minimum legal obligations and entitlements. Be aware, state and territory privacy laws may still apply to certain employee information, despite the employee records exemption under the federal privacy laws.